Okay, good afternoon, everybody. Chair Dave Mendiola. Vice Chair Laura Fitzsimmons. Joni Easley.
Yep.
Chris June Kiliani. I see that she's here. Jeff Wells.
Here.
Drew Christensen.
Here.
Rob Tellis. Hi, Chris.
Hi, sorry, I couldn't unmute.
No problem. Kate Thomas.
Here.
Bevan Lister.
Yes.
Commissioner Hall.
Here.
Allison Jaffe.
Here.
Harriet Cummings.
Here.
And Justice William Maupin. It looks like we have a quorum.
Great. Thank you, Cynthia. So first order of business, public comment. This first public comment is limited to comments on items on the agenda. No action may be taken upon matter raised on the public comment period unless the matter itself has been specifically included on the agenda as an action item. The chair will impose a time limit of 3 minutes. So we're going to open for public comment. Do we have any public comment? See any hands raised online?
Nope.
Did we have one written comment?
Excuse me?
Did we have a written comment?
Oh, no, we don't. No
Okay.
written comments as of now.
Okay, thank you. I guess at this time, I'll close public comment. We did have I had a note here, Marcy, that Sue Savon from Churchill County may be on the line and you may want to put her up front. Is that still the case?
Chair Mendiola, I did talk to Sue. She was unavailable this afternoon, but I informed her of what would be requested and she supports it.
Great. Then we'll move on to item 3, approval of the April 28, 2022 minutes. Has everybody had a chance to look at those minutes? Any edits or changes to those minutes?
Mr. Chair, I thought they were an accurate reflection of what happened in the last meeting. I believe the motion to approve.
Okay, got a motion, got a second? And a second from Allison. Okay, everybody understands the motion. Everybody in favor, say aye.
Aye.
And any objections?
No, I have to abstain because I wasn't there, so I have no idea exactly.
You have no trust. So Jeff will abstain from that. So let's move on to item number 4. This is review the 4th monitor report. And Peter, I think you're going to handle that. Or actually, Tom's there.
Yeah. Okay, so we have the 4th report of the Davis monitor. It's over 30 pages long in substance plus the attachment. So I won't go through it in any detail, but I wanted to just touch on the introductory summary, which lists the achievements and some areas of concern, and then we'll talk about kind of what we're doing regarding areas of concern. Best of not, I believe, is on call also, so if you have any questions, we can answer, or she probably answer better. She notes the achievements, recent achievements of the department as that we have since January of 2022. Got our in-person oversight visits. This is sort of part oversight and part relationship building, and the reports that are generated from each of the times we did so far are attached to the back here. We have contracted with a data analyst to develop an oversight plan. Sure. as well as a wage and salary survey. We've completed our efforts to assist the counties with their plans and with their systems for appointed council administration, basically, which is the selection council and the approval of fees and services. We rolled out the legal server case management system, and we've done an outreach to all of the providers of all of the local counties regarding staff collection, which is like training, as well as all of the follow-up, additional sort of edits to the system. We have analyzed and published 2 different quarters of data based upon legal server data entry from the practitioners in the field. And we put on our second annual convention and Las Vegas scale. The areas of concern that she touches on are adequate timekeeping for the workload study. We are working with NCSC to do this workload study, and everyone knows. And we pushed off the conclusions of that a couple of times. The first one because of COVID situations, and this last one, combination of factors. One of them is, again, because everybody's still getting used to and working out clubs with legal server and their own entries. And sort of the sample size that we have from the small number, relatively small number of practitioners that we're gathering this from, as well as the fact that the Rank Corporation is doing a national study on caseload, and that won't be out until September, so you can't use those numbers or reference those numbers. So we're trying to get more data from our own system as well as be able to incorporate the national standards. So that's how we're addressing what is right now sort of shortage of data. Insufficient number of attorneys in some counties. This has been a problem that we've been addressing for some time, and it's why we have a pipeline program with UNR. It's why we're working with the counties to offer incentives and possibly, like Ryan and Douglas, increase the hourly rate for appointed counsel. Different strategies that we're working with counties with the resources they have right now to attract more practitioners. Of course, in the long term, we're working on building bigger budgets. We have which we'll get into later, we have the reimbursement requests that are currently before the IFC. So hopefully the system as it's supposed to be set up will keep more money. Budget for oversight has been trouble with our small staff, and in fact we have very little in-state travel money. Means that our oversight is a little bit limited, so we try to really address everything in these visits, both observing court and relationship building. Second one, budget for travel, mentorship, and trainings, sort of wrapped up in that. And as part of our budget bill for the future, we're looking to increase that pretty substantially. So that's all I'm going to touch on for that. This is in the packet. I can go into more detail about any of it if anyone has any questions, or again, I'm sure the professor.
Okay, great. Let's start out right here. Commissioner, do you have a question?
Just to actually typo there in that last section that you were addressing. About halfway through, it says, for example, the has no host fund. So
Okay.
we or it or the or somebody.
It's the department, right? Yeah, and that speaks to the difficulties we had putting on the training as far as that host fund, we can't pay for food beverages.
Understood. I just, and don't get it wrong, I'm not the English teacher. I just noticed that in reading. So
Thank you, good eye.
Are there any other questions about the fourth monitor report? Out in the audience online?
Mr. Chairman, I have a quick question for Tom. Who commissioned that rate report? I haven't heard about that. They're doing a nationwide study.
Yes, nationwide study, I don't know, did NCSC, or is that, I mean, they kind of did the same thing, NCSC, right? Scale.
Yeah, we had discussions with NCSC, and that's why they requested that we do a no-cost extension for our rated caseload. They're involved in Rand's study, and they have access to the data, but can't publish it in our report until the original report comes out. So they're involved with that. It sounds like it's a group effort, but we don't have that much information as to who paid for it.
Do you know where they're collecting the data from?
We don't have that information, but we can ask NCSC, but I don't know what they're allowed to distribute or not distribute.
But they're not including our data here in Nevada with that report or something.
For that report, I don't know. We've given them the data that we have, which is limited.
So I have a question. It sounds to me, something I was reading on that is the idea is to take the data for Rand along with ours, somehow mold them together and get some more accurate.
Correct. We're also doing, or NCSC is doing follow-up Delphi panels. You know, the first Delphi panel, of course, was during COVID. But they're doing follow-up Delphi panel studies. And so it will be kind of a fusion of that, the data that get collected from us and these nationals. And some of the data that's critical and unique to Nevada is like the travel time in some of our rural counties, like, you know, some of these counties have quite a bit distance that the attorneys have to travel just to go from courthouse to courthouse. So that factors into caseload standards for those counties.
And Professor Hanan also was concerned that she wanted to have a survey sent out, which is a standard practice. So NCSC did put together a survey, sent it out to the indigent defense attorneys for the rural counties. So when we receive input from Professor Hanan, we are taking that into consideration and passing that information on. We want it to be the most accurate.
Chair, I have a question concerning uniform data collection and reporting. And I know the report said that the submitting data will get better over time. Are there any actions that counties can specifically take to encourage the public defenders to submit their?
Well, this is something that we've been working on from the beginning, but for instance, it's in all of the new contracts. When we rolled out Legal Server and when the reporting requirements began, some of these attorneys, some of these practitioners were kind of in the middle of their existing contracts. So there's a little bit of an issue as to whether you could unilaterally add this condition when it wasn't part of the negotiated contract. But as the contracts come to be renewed, it's required that that provision be in contracts, that in order to hold this position, you have to comply with all of the regs and you have to use Legal Server at a few times. So at least one county that we were recently talking with has changed that in the contracts.
And then, Mr. Chair, I was remiss in not introducing Rita Dellinger, Assistant County Manager for Granada County, and the individual for Granada County who was instrumental in administering the contracts. Just as a.
Great to have you, Rita.
I had a question about the training, the budget for training. It seems like a lot of our attorneys came to the training in Las Vegas because of scholarships. They were able to attend those. And I was wondering if we, if as a board, we could do something to up the scholarships at other places like NACBL, National Association of Criminal Defense Lawyers. So I think scholarshiping and allowing people to learn, but also to be mentored and to have maybe a partner, you know, a referral or attorney, Reno or Mercedes to kind of partner with and call on, so we can help them, you know, do better with maybe more, you know, group training, but then maybe more individualized training. So I think that's, to me, that's a huge issue, is the training for our indigent lawyers. And if they know as part of their contract, they're gonna have even more training than they could have in their private practice, I think that would be a draw and certainly help the candidates.
Yes, certainly, Peter Manning for the record. Sorry to be extra loud. Apparently our sound quality isn't quite getting through everybody. Hopefully it's getting better. I did the microphone. So a few points. Yes, I absolutely agree. The more training we can get after practitioners, the better. One of the better reviews we receive as an organization is we're really happy we're getting free training from knowledge source. The grant we received from DPS, the Center for World Attorneys Conference, was a one-time sub-grant of the Jack Byrne Memorial Scholarship or Memorial Fund. Hopefully we can renew that. If not, it would be nice if the legislature sets more funds aside for our training budget so we can both pay for more attorneys to attend different locations to change up the conference venue, provide more individualized training. I think next year we're looking at already is do breakout sessions with active practitioners, doing something like opening and closing statement, building themes and theories, how to develop those opening and closings, how to tell a story during those sessions, and really being able to have attorneys walk that through with other practitioners, how that will sound, how that will look, and improve these presentation skills. So certainly, the more funding we get, the more funding we can put to use and bring in experts from around the country, as well as in the package, trying to put on better trainings, put on more individualized trainings, to develop better written materials and resources for attorneys.
Any other comments here in the room regarding the fourth monitor report or out online? Anybody online would like to comment?
Hey, this is Eve Hanan. Can you hear me?
Yeah, I was going to come to you next.
Great, wonderful. It's a little bit garbled on this side, but I just wanted to thank the department for continuing to be so transparent and meet with me and answer my questions, even though I know that their time is quite precious and they get a lot done in every week. So thank you, and apologies for any typos. My very valuable assistant, Cynthia Johnson, was in the middle of her law school exams and wasn't able to help me with the editing. So I hope there aren't too many. So thank you.
Great, thank you, Professor. Appreciate your work. If there's not anything else, we can move on to item 5.
Dave, I just have one clarification under the Nye County report. On page 5 on the Nye County report, the second full paragraph. There is a federal prison in Nye County. There is not a federal prison in Nye County. It's a holding facility only. That if it's worth mentioning, I just want to make that clear. It's a holding facility.
Noted, it's a detention facility. And my understanding that is that the contract attorneys there do handle some cases that arise out of that facility. Is that correct?
Marina could probably answer that question.
Marina Dellinger for the record. We do have a contract with police, which is a holding facility for the inmates. But the detention center also holds our county detainees.
No, they're talking about what Commissioner Cox wants called the prison in Rome. It's
Oh,
not.
core civics.
It's a.
The core civics, is that which one we're referring to? Yes, that one is not a county federal facility.
And I think the question is whether our public defenders were representing those.
No, they do not.
Oh, apologies, it's a little garbled on this end. I couldn't hear that. I wonder if somebody who's a little closer to a microphone could just repeat it for me.
The Lake County Public Defenders do not represent the inmates at the federal facility.
So it's our understanding, again, just based on reporting from the Lake County contract defenders that they handle the equivalent of our prison cases for detainees or inmates that commit offenses while in custody in Lake County. They represent those. Again, that's our understanding, and I'm happy to clarify in details of that.
Lorena, that information came according to the report directly from some of the public defenders. Nathan and Jason, Rodney.
Okay, I have not seen them reporting on that.
It's possible, Jimmy, because I know even in Las Vegas, we have not a lot of cases, but when they're held in the I-county facility, they're facing, many of them are facing a federal charge in Las Vegas. But if they have a little companion state case, one of our lawyers has to travel to so there's like dual representation, like a federal public defender along with county public defenders. So my guess is your I-county people don't represent them as a force, but there may be occasions, as Tom said, where they might have a listening that's filed in custody, which would be an jurisdiction, but they may also have dual cases.
So who compensates them for that?
It's part of their contract from what we understand, and
Part of their contract with Nye County?
they're in federal custody based on federal charges, and the Nye County public defenders don't represent them on those charges. But if they pick up charges while they're in custody,
Oh, I see what you're saying.
there, then they will represent them on that.
Might as well take that one with you.
This looks like a lot of competition. Okay, any other questions?
Commissioner, if I could just make another comment,
Your mic is on.
trying to figure out how to turn on. I was just being asked about training. I just wanted to comment. The training that the department did in May in Las Vegas. I was the first day, I was an lieutenant, and the second day, but on the comment, I what it was, I was surprised at the number of attorneys who I didn't know, which meant they were from rural parts of Nevada. And the presenters were members of our Supreme Court, members of the bar from Northern Nevada. So I was impressed with the level of preparation that we're in. And I really think it's about second day overall. So I think the support for that program here around the state is I went to that perspective.
Yeah, thank you. I heard the same thing from Humboldt County's district public defender. Came back with nothing but good things to say. He's not a guy that usually says good things. Sorry, Matt. All right, so if there's nothing else on that, we'll move on to item 5. That's update on the department. And I've got Peter. Is that correct?
Sure, why not? We've already covered a few of these things, so I won't go too much.
Yeah, there's going to be a couple redundant things I saw.
Yeah, I'll start with item A, contract with Dr. Terry. So we contracted again with Dr. Terry, a few months ago now, to continue to conduct the caseload workload study and to make some recommendations as to how we can best implement some of our regulations in practice. He's already completed an analysis or salary parity for the state public defender's office. So we have developed a pay bill so that eventually the legislature recommending that the positions in the public defender's office better match their counterparts in the attorney general's office. Because right now, as it stands, several of the chief public defenders aren't paid as well as their counterparts, chief deputy attorney generals. So we're recommending those be brought to parity, and Mitch has done a lot of forever for that, for us in that regard. Right now, he's working, doing comparisons to several states, to kind of discuss what might be a good hourly rate for attorneys. Again, as you know, we've looked into potentially changing what the hourly rate might be in the future and how that should be developed, and Mitch is doing some research for us in that regard as well. For me, we already talked about, we received a no-cost extension of the NCSC rated caseload study contract for like a year. So when they finish those caseload study analysis, we'll actually recommend this board and regulations as to what caseload should be for attorneys in various counties. How many attorneys might be recommended for any given attorney in the county.
Okay. Very good. Any questions about any of that information? Okay, go on that. Thank you very much. Appreciate that. Item number 6, we'll go to training and externship update.
If we are ready for the record, I'll take this one again. Yeah, thank you for the comments already. We had our second annual, the first in-person annual conference in May the 26th and 27th. We had a really good turnout. There were 20 scholarships awarded based on the scholarship I explained earlier to rural attorneys to attend. So far, I think we've begun the repayment process, or about half of those already. We're hoping to get them all reimbursed for most of their expenses before we get one. We expect to have used about half the grant funds. Of course, there aren't that many rural attorneys, and they can't all take every day off to come to conference. Some still have work, some have routine duties, some are expected to cover for their coworkers and so on. So we can't expect everyone to show up. But we had a really good turnout. Over 40 attorneys were present both Thursday and Friday for CDC with credit. There were another approximately dozen attorneys present each day, not receiving credit or not requesting credit. There were various investigators, mitigation specialists, and several students from Royal School were also in attendance to watch the conference. We had excellent presentations, and again, as indicated by members of the Supreme Court of Nevada, former Supreme Court judges, Justice and Chief Judge Bell from that. And we had some great speakers. The total unit count for CLE was 11 units, 1.5 hours ethics, 1 hour of substance use rights. So took care of most of those hard to get units for the attorneys that were present. We had some sponsors that paid for a lot of the things. We had legal server pitched in some funds, Westlaw pitched in some funds, savings practice, Dr. Ford's business, contributed a significant amount, enabling us to have some social events for the attorneys really from all around the state to get together, get to know each other, interact on a personal level in addition to professional. So we thought it was I think it personally was an excellent conference. Again, as I explained, we hope to do something similar next year. We have hopefully better, more detailed instruction. We're going to build it off what we had this last year and developing further to the forward. As for externships, there are 2 kind of programs we have. Currently, the department has 2 interns and 1 extern we're hosting for Royal School of Law. They help us out at the conference. They're doing some research and drafting projects for us for the summer. Most of those are in regards to potential bill drafting efforts. Some of them are doing research on best practices, and they're coming up throughout the country to try and help improve our base of knowledge to help the attorneys here in Nevada. There's also the externship program that's funded by State Bar Grant. We have placed 2 lawsuits, one with the Elko County Public Defender's Office and one with the State Public Defender's Office in Carson City. Both of them have received a $6,500 stipend to cover room and board and other various expenses over the summer to offset the costs of being able to intern in a rural county. That program continues in perpetuity as well. We do have funds set aside, I believe, for next year from the bar, so we'll have next year ability to cover payment for 2 more lawsuits to intern, and hopefully we keep that going forward with the same bar or other sources of funds.
Thank you very much. I have one question on that. So on that externship where you're placing these folks, are they, and again, this is coming from a layman, sorry for this, are they getting second seat experience, or is it just more of the clerical type things in the background as well?
So the way we have it structured, applicants right now, we're recommending maybe 2 L's, coming up to 3 L's. So in the Supreme Court rules, they actually can get some practical experience. They can argue motions, they can represent clients in misdemeanor trials, they can sit secretary, felony trials, and supervisor. So they're really going to get button the chair experience, as you might describe it.
I would seem to be a great experience to do something. Any questions, comments? Okay. So we'll move on there. So we'll go to number 7, review and approval of annual report. I think you're going to handle this one.
Thank you, Chair. I'm told by the person who transcribes this that I have the highest word count generally. So I'm gonna try to limit this. Again, you've got the annual report in your packet. A lot of what has to be in here is data heavy. But we wanted to kind of take a little bit different approach and humanize some of what we do and what people in the field do. So while we cover all of the things that we do, you know, this framework that we're building, including our ongoing legislative efforts, our data collection, our continued drafting, reimagining events and each of the counties, the individualized plans, our and our oversight. We also kind of wanted to talk a lot about our bigger visions. And one of those, as I think I've talked about before, includes relationship building across the state. So that's a big part of what Marcy and I have been focused on, is going out, you know, getting off the Zoom meetings and shaking hands and sitting down and learning with people without really an agenda. And we learned so much more about how the counties work and how the system works and what their actual needs are, just by opening up the conversation. One of our non-county conversations, Judge went over 3 hours. Just we never really know what's going to happen there. So we try to include county management. We try to include judges and, of course, all of the practitioners and any other stakeholders in that, so we can get sort of more of a holistic picture of what's going on and what the needs for the future are. It allows us to make recommendations and, you know, and add some guidance as well based upon what we see and hear, things that people, you know, hadn't thought about how we can change and expand their indigent defense plan. So that's a huge piece of it. We highlighted our wins. One of my favorite things is these highlights from the field, in which we kind of just randomly select people or people who have been in service for a long time. Matt Sermons was one, and it's my favorite sort of. We asked people to talk about their wins or things that they had accomplished, and Matt, although he's done this for a really long time and had lots of wins, gets the prize for the best story. So he says jury trials in small communities are generally serious affairs. There's much at stake, including a person's liberty, family, and future. But it's not always the case. In one instance, a client was charged with a misuse of emergency phone system for calling 911 to report that a fellow camper had drank all beer. The jury acquitted him, finding that running out of beer while camping was in fact an emergency. So you can read the other highlights, and then we end up with talking about one of our visions, which is creating sustainable indigent defense systems across the state. We've done this a lot, but we're approaching this from a number of different directions, anywhere from legislative efforts to grant funding to with the maximum contribution formula and state reimbursement, building systems, including, for instance, county offices where counties couldn't previously afford to do that allows for additional attorneys, maybe investigators, and the ability for these practitioners to have like some first benefits and to qualify for public assistance, student loan forgiveness, these kinds of things. Again, there's a shortage. There hasn't been a
pipeline into the rurals for decades, really, so we're working on that. We're working at all angles, from Boyd Law School to funding to reimagining what these things can look like in each county, so that we achieve parity with prosecutors' offices, but also so that we provide these practitioners with a sustainable sort of, way to make a living. And we're happy to take any questions.
Very good. Thank you. Appreciate that. Are there any comments, questions here in the room first? Don't see any. How about online? Anybody have any comments about the annual report? Okay, it looks pretty quiet out there. I just want to say thank you. I thought it was a great report. I actually read through all of it. Don't recall any of it, but that's pretty normal for me. But anyway, I do think that was a really nice report, and I agree with you. I don't know if the other counties are having some of the same problems we're having in Humboldt around, this new requirement for jury trials for domestic violence charges, but it's got us in a tizzy, and it's probably going to cost us somewhere between $10 and $15 million just to meet the requirements of the legislation. I was thinking from a BDR standpoint, something we may introduce, we're trying to introduce to NACO, because these unfunded mandates, which came in a different form this time, are really problematic, to your point. So,
And Chair, before you move on, can we also get a motion to approve it, and disseminate it to the governor and any other parties?
very good. So we've got a motion to approve the annual report.
I'll say.
We got a second as well. Any questions on the motion? If none, all those in favor say aye.
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 Any opposition, say nay. Passes unanimously. Thank you very much, appreciate it.
Mr. Chair, I have a question for Marcy. It's only open cases per county. I realized that's only for a 3-month period, but was there any concern on your part about the number of cases?
And I don't know if we have concern at this point in time, like Tom had touched on earlier on, many of the attorneys didn't have parts in their contract where they had to comply with legal server, so we didn't get full reporting from every single county. So the reporting that you're seeing is basically October to December.
Yeah.
So it's very limited because our regulations were new, people were learning how to use the system. But as we are rolling out the system more and more and being available for training, the response rates have been higher. So as we look at our quarterly reports, we see better data each quarter.
The monitor reflects that in her first report as well, that she was encouraged by the difference between the numbers that you see here and the second quarter. It's much more robust, and we hope that we will grow as this becomes more and more part of these practitioners' normal daily lives. Change is hard, we all know that, and now that almost everybody is required to use it under their contracts.
And I'm assuming some of them don't have staffs, so they're doing this reporting themselves, and if they're already having cases. This kind of falls into the priority list.
Sure, that's correct, and there's an issue, we would like to compensate them or provide them with incentives somehow for using this. We applied for a grant to provide Westlaw with a research database to all of the practitioners on our list. We did not get that grant. We continue to try to do that through other sources, and that would also be great if, for council, for instance, we could pay them we can't do that. This is
not really related to this topic, it's related to the last comment about the jury trials for misdemeanor domestic violence cases. I'm actually chair of the subcommittee for domestic violence down in Clark County, so we have judges, ULB professors, a variety of DA's office, office. Every Friday, we schedule 20 potential trials for AV cases. We've been doing this since the beginning. You know, how many months that is. Guess how many trials have actually gone? In that entire length of time, yet we're going through the cost and expense of setting it up, calling in juries, doing all of these other kinds of things. We got no one. So I concur with your comment about some of the indirect mandates that come when we talk about.
Thank you, Jeff. You have something else?
I had the pleasure of doing one of the trials in Carson City, one of the first after COVID. And I think as I see it from my defense lawyer position, it certainly gives you more to talk about. I think it's a fair and law. Judges were just finding everybody guilty no matter what. So I think it's much better to have a jury. But I think part of the expense is actually setting up the jury box and the that's something that our issue. We have a specialty, special program. But I think the reason that things, that the trials might not go forward is the same with a lot of criminal cases. If you have a well-prepared attorney who says, we're not going to take that application. We're going to go to trial. Know that our at least it's 50-50 and something better than that. So I think when we have a prepared group of defense lawyers and they say no, then you do have some more free bargaining. That is a lot more realistic in some places. So I would just say that it's worth it to have the system.
My comments really not from the other side, it's just the cost of the construction. I actually grew up in the Colorado system, and every misdemeanor that had a potential confinement in a church. And so I used to be a week church house and everything. So this is just the cost of the council.
Yeah, and I have a question I had that, so I agree with that. When I talked a little bit about that house, and they deserve that opportunity. But the problem is we went from 6 jury members to 12, and we were almost unable to do it, renovating with 6, and then it became 12, and it's impossible. So that's what the problem is. I just wish this is not going to fall on deaf ears, but the legislature think about that when they make these kinds of decisions, that there will be consequences, especially in small towns. Well,
Actually, it was a Supreme Court.
was the Supreme Court, I thought it originally, and then within the legislature also.
Now, the legislature came in with the Ramos case in 84 after the Supreme Court.
Okay. Okay. Thank you. Any other comments? We've got the motion on the floor. I think we did that, right?
Excuse me, Chair. I believe Chris had her hand up.
Okay, please do. Go ahead, Chris.
Yes, I do, Cynthia. I'm sorry, it's just so garbled. Could you restate briefly the motion? And I heard Jeff mention Colorado. Outside of that, I lost the last half of the conversation.
Sound any better?
Not really.
No. I'm assuming that it's picking
So
up.
at least that's better.
That's better now. So.
Yes,
Is
thank
that
you.
any better right now?
Much better. Thank you.
So maybe it is that we need to keep. All mics off, I'll be sure to turn this off on this one, so. Okay, so, I think we have a motion, on the annual report. And, the motion was to approve, and I believe we've already approved that, or, yeah, we took that. So Chris, we did approve that, if you missed that.
I thought we had, but then you restated that we would vote on the motion. So, okay, got it. Thank you.
All right, so let's move on to 8 bill draft submissions. And we'll turn that over to Marcy.
Thank you, Chair. Marcy Reba for the record. To start off, I just wanted to update you on our policy bill draft requests, which were due previously. We had received permission from the board to put certain requests forward. So we did, that allowed us to amend our grant fund that we have. So we don't have to put our grants in, we can also put it into our regular budget. Our second is regarding confidentiality of certain records, that's been approved. And the third matter that we had discussed was to kind of change the approval of our budget by the board. We had concerns that it needed to be confidential. After talking to Governor's Council, that was not necessary. We are allowed to talk about our budget, so we pulled that request and just submitted the 2 policy requests that you see for you. It is quite lengthy because we attached Davis to the request, so that's the biggest part of it, but we just printed out for you what we had submitted so you can see it. So moving on, we do have a couple of budgetary BDRs that we've thrown out there. Of course, we're open to any other BDRs that you'd like to discuss. The deadline for this is September 1st, and we do have another meeting in July, so we're unable to complete the discussion this time. We still have another opportunity to finalize the discussion. The first request that we have is regarding the attorney-client privilege. We want to propose language that maintains that attorney-client privilege when an attorney is communicating with bids for compensation or reimbursement of requests. This process has been going on for a long time in Washoe and Clark County, where requests are submitted to the appointed council administrator to make a decision as to whether funding requests can be approved. We want to clarify that that does not waive the attorney-client privilege, and we've modeled this proposal after language that's in Oregon. So we do have a request to say, notwithstanding NRS 49.385, which is a waiver of privilege by voluntary disclosure, privilege is maintained under this section, which is the attorney-client, for communication made to the Department of Indigent Defense Services or its designee for the purpose of making pre-authorization for or payment of compensation for expenses under NRS 7.125, NRS 7.135, and or NRS 7.145. I don't know if there's any questions on that proposal.
Do we want to vote on these individually or collectively?
I don't know how you feel, I don't think maybe individual.
That's exactly what I was thinking.
That way nobody forgets what they thought. Get to the 4th.
Yeah, I had a comment. There were some concerns from the bar that the confidentiality may include successor counsel's access to the information that was provided to this. That's not the intent of the statute. That's not what we currently do in Clark. All the disclosures and discussions between appointed counsels, program and appointed counsel are privileged, but they're always, we look at this as the client's possession. So on state habeas, federal habeas, and successor counsel, the trial or whatever, is always entitled to the documents that it produced to this. And so I think we alleviate that concern. That's the policy that ISLO's had as well. irrespective, I don't believe this statutory change that suggests that the privilege is for the benefit of clients. And so successor counsel access to that information is still privileged with the back already. So any fears about that, I think, should be washed. Or at least have concern.
And thank you. We did reach out to the Nevada Attorneys for Criminal Justice, Jim Hoffman, who I believe is on the phone. And he did address that concern that he wants to make sure that if attorneys are requesting funding from the department, that a client can make that request to the department to get those records. And that we wouldn't be able to say that that's privileged. And we do agree with that stance that a client always has access to those records, would have access to that. But that is feedback that we received from that, from Mr. Hoffman.
So Chris, do you have some comments? You had your hand up a moment ago.
No, I don't. Thank you.
Okay, thank you. So any other comments, questions on this first request here?
I move, are we saying adoption or recommendation to file? What's?
We would ask that we get permission to file this. We are required to provide this wording to Governor's Council. It would ask to be able to modify as recommended.
I move what she said.
I'll second that.
All right, we have a first and a second on that. Does everybody understand that? All right, we're good. So all
Yes.
those in favor say aye, please. Aye.
Aye.
Any opposed? Okay, passes unanimously. Let's move on to the next.
Thank you, Chair. The next is to modify NRS 260.070 regarding the time period for annual reports to the department. The current due date is May 1st. We've received feedback from the counties. They feel the due date should be May 31st because they are required to transmit their budgets to the state by May 31st. And they don't have the information to be able to provide to us on their budgets until that day. So we are asking permission to move this request forward as well to modify subsection 2.
Go ahead, Jeff.
Well, I think, I think I was one of the counties that made this suggestion, so I'll move this one with the same parameters that we set for the last one.
A second.
Yes, I think this is a great idea and I second that motion.
Yes, I agree with that as well. It really is a problem with me first. All right, so we have a motion on the floor. All those in favor, say aye.
Aye.
Any opposed? We got none. So that's, that passes. Next item, number 3.
And Chair, would you like to hold off on number 3 till the end? I think there may be more discussion on this.
Yes, that would be a great idea. Let's go to 4.
So moving to request for, we had shortly this, or requested this at the last meeting, NRS 7.145 provides that a claim must be submitted within 60 days for payment. And we have seen situations where attorneys have overlooked certain bills, did not get those in that 60-day time frame. Of course, the county did agree to pay those bills. So we are asking to modify that statute to change the 60-day time period to 90 and to add language that unless otherwise permitted by the county, to give them that authority to expend it past that.
Any questions and comments on that?
No, Mr. Chair, I think it's reasonable and I would make a motion to approve.
I would second that motion.
Okay, we have a first and a second on that motion. All those in favor say aye.
Aye.
Any nays? Very good, passes unanimously. Let's move on to the next.
Request 5 is to appropriate funding for reimbursement of expenses related to representation of prisoners to the department budget. Pursuant to NRS 7.155, any expenses related to representing an incarcerated individual, actually 212.070, any expenses related to representing an individual are a cost to the state. At this point in time, the department nor the public defender's office has those funds within their budget. And in order to provide payment, a bill has to be submitted to our department and we submit it to the finance office for further submission. It is a time-consuming process. One of the statements in Davis is to provide prompt payment for representation, and this does cause a delay. So what these two requests are in NRS 7.155 is to have funding set aside for representation of a prisoner under NRS 212.070 in the budget of the public defender's office, which currently has a budget to reimburse post-conviction petition for habeas corpus. So it'd be the same pot of funds to be able to pay these. And then NRS 212.070 would be just to add language that says the compensation and expenses of an attorney appointed to represent a defendant are a charge against the state and must be paid from the money appropriated to the office of the state public defender pursuant to NRS 7.155. But after the appropriation of such expenses is exhausted, money must be allocated to the office of the state public defender from the reserve for statutory contingency account for the payment of such compensation and expenses. So we are asking for permission to modify that.
Okay, does everybody understand the request? And are there any questions or comments? Okay, I'll take a motion.
It makes sense to me. I'd make a motion. This is Chris.
Thank you, Chris.
I'll second it.
And we have a second as well. Everybody understand the motion? If so, all those in favor say aye.
Aye.
Any nay votes? That passes unanimously.
Thank you, Chair. The third, which is request number 3, is to modify the hourly rate for appointed counsel. And what we have written here is to be consistent with the CJA hourly panel rates. So we are requesting, again, this is just a starting point, but we are requesting to increase the hourly rate for death penalty cases, which is currently set at $125, to be set at $202, which is the current CJA rate, and the $100 per hour to be increased to $158 per hour. We also pulled language from the Constitution in the minimum wage statute, which you see there, that says these fees shall be adjusted by the cumulative increase in the cost of living. The cost of living increase shall be measured by the percentage increase as of December 31st in any year over the level as of December 31st, 2002 of the Consumer Price Index, as published by the Bureau of Labor Statistics, U.S. Department of Labor, or the successor index or federal agency. Additional information I would like the board to know about this is Dr. Macharian, like Peter has said, is looking at surrounding states to determine what the appropriate rate should be. We started with the CJA panel out because they did a huge study to determine what that hourly rate should be, and that's what that's based upon. We also are seeing the market pay similar rates. Some counties are paying $150 an hour for appointed counsel for felonies and gross misdemeanors, $125 an hour for misdemeanors, and $175 an hour for death penalty. So it seems that the rural counties are paying a higher rate than the 100, just to be able to get counsel to take the cases that they can't find anywhere else to take. Another thought that there was concern is if we follow this information is whether December 31st, 2022 is the appropriate year because inflation is, or the CPI is so high at this point in time, so we may want to modify that here to 2019. And then finally, whether we should put a cap, if this language is acceptable, that the increase can be no more than 3 or 4%. So that is feedback that we have received.
Thank you, I appreciate it. So this one, I know we do have some comments and concerns, so I'm gonna turn it over to Jeff, let you start.
So we in Clark County support the concept. The concept is to get a higher hourly rate. As an editorial aside, I know when you did the in the report and the study, one of the goals is having parity. I'll also mention that we've had parity even for the institutional defenders in the DA's office for 20 plus years at least. And also for any of the Clark County folks who might be listening, I'm actually planning on the first meeting of August, bringing a increase to our criminal track attorneys moving forward. My concerns on this write-up, however, are multiple. First off, your last example is one of the things I don't like about it. You struck out the last sentence, which allows the county to do something different than what's in here. So then if we only decide on 158 and the rural county wanted to go to 200, technically they can't, because you're taking out the language they're using now to go above the 100. And so I think you want to leave that language in there. You want to recognize, I believe, that one size doesn't fit all. To me, the correct end solution is not to change this in statute, but to remove it from statute. Leave the ending language, which allows the counties to set their own rates based on what they need, providing this board the opportunity to review those agreements. And if we decide that what they have paid is insufficient, or they're contracting for is insufficient, then we could go and seek a corrective action to try to move it. And that way, each county has its own option to go higher. And as you said, right now, there are counties already going above the rate that is being established here. And you don't want to take away that right. Now, in our county, we use track attorneys as well as individual case attorneys. To put this in perspective, prior to COVID, the year just prior, we paid for 67,000 hourlies on top of our tracks. So when you're raising this, then Clark will have to start asking for the extra money out of the state. All of a sudden, it's dwarfed everybody else's request. But at the moment, we don't even try to seek extra money so we can save it for the rest of the rural counties to move forward. So the concept makes sense, but it's not needed. Just take out the hourly rate so we don't have that minimum. Leave the requirement, not the requirement, the option for the counties to set their own rates. And then we review each county, their rates as part of their plan, do corrective actions if we need to. It's an ancillary small thing. Well, I know this board is dealing with criminal defense. This statute deals with any appointed attorney. You'll be triggering increases in dependency cases, guardianship cases, everything else that's out there, because all of those statutes refer back to this when they establish the hourly rate. So again, another reason not to make this change.
Go ahead. Go ahead, Allison.
Thank you. Things I've been practicing for over 30 years. This has never changed. This is the rate that is offered. And I think it's imperative for us to raise the rate. And appreciate what you're saying. We would have, if we did that, then we would still have $100 an hour or $125 an hour in a lot of counties. Because the folks in the counties have a lot of pressure on them, and at least at this point, I mean, I think it's getting worse in terms of the respect that people have for defense attorneys and the need for defense attorneys. I think we need this language, and if we could kind of fine tune this language with the language from request number 4, where we say unless otherwise permitted by the county, I think we should only have the language on would be, but if the counties wanted to increase in certain cases, the pay, especially for the death penalty cases, but for all the cases, I think that should be authorized.
We did, one of our last discussions was to have it, to change the language from master plan to greater. I think this would be a fuller, but then the counties, to your point, would be allowed to, contract for hire. You know, we do have some concern, about the politics of pushing this through, so we're trying to be very careful there. The state is very nervous about numbers that aren't defined, that they can't, you know, see into the future for. So that's the only reason why we put that in the last minute. But if the board thinks that that's a good idea to have this for.
And I'd like to respond to that too. We're trying to kind of streamline the system, and my concern would be if we would have to go to the county and say, no, we don't like your judgment, we need to pay more. I think that sets up an adversarial role that we totally do not want. So I think if we have this, we are requesting, I think we should do it.
If I could just follow up with a story that I was just sharing with Drew. As we all know, our department is serving as the appointing council administrator for a lot of rural counties because they just don't have staff to be able to do it. We had a certain case in Lyon County where for 2 weeks, we had called every attorney on our list. We had emailed them multiple times. The case had no court date set, yet because there were co-defendants with it, we were just unable to find anyone that could take the case. So I reached out to Drew, and I said, we've got this problem, we don't have anyone that's able to take the case, this court date is coming up, what do we do? So Drew thought about it, we found an appropriate candidate that was willing to take the case, willing to travel up, and although he's retired, he's willing to take these cases once in a while. Well, this is $100 an hour for him to travel up to Lyon County from Clark County, where other individuals that had entered into a contract were making $150 an hour because counties are using NRS 260 to allow these attorneys to enter into a contract for the higher rate. The contract needs to go in front of the board. But when we have these situations like this, where there's just no attorney in the rural that's able to take it, we don't necessarily have the time to always enter into a contract. The county doesn't have to enter into a contract. And because of that good relationship we do have with the county, they did agree to enter into a contract with this Clark County attorney, so that he could get that higher rate and be encouraged to come up there. So that is our concern, is that if we do keep it that $100 an hour, how are we going to be able to act quickly if we have a client right now where we can't find an attorney locally to take these cases, where we have to pull from Clark County for someone willing to come up, do that travel time to get up there, but we want them to be paid at that higher rate, which is consistent with everyone else is getting. So that's one concern that I have. I think it's been brought up as well with the language that we crossed out. The reason that we did it is because it clearly says they can contract with someone for a lesser rate of compensation. It doesn't say anything about that higher rate of compensation. And then again, we are aware of the impact this will have on the 432E cases. But again, when we're going out to the rural counties, that's the biggest feedback we're getting is, okay, if you have these public defenders, do full-time public defender to take away 432E cases, who's going to cover that caseload? And I think if we increase the hourly rate for everyone across the board, it would encourage more individuals to do this sort of public service, to take on these cases, knowing that they'll be able to meet those overhead expenses. So that's ultimately what our goal was, is we're going to these counties, we're listening to their concerns, and there's just not enough attorneys in the rurals, and we think this could be one solution.
That reminds me of the legislative axiom that bad facts make bad laws. We shouldn't set up this statute for the isolated cases like you're talking about, and it turns out it was resolved and that person actually got the higher rate, all without this statute. Does your last sentence imply that counties to use the track system like we do, so we pay folks a flat monthly fee regardless of the number of cases they get? Are all those now going to be converted to hourly cases as well? Because the 67,000 hours I was talking about was all the hours above our track cases. It didn't talk about how many hours they spent within the track.
Does your track system, are you able to do that under the current language of the statute, which says you can contract for a lesser?
Well,
And I can take this. Historically, Clark County, even going back to when I started in the eighties, has always put together a system that if the charge was a category B or lower, it was part of the monthly stipend that the attorneys received for those representations. If it was category A or above, that's when the 125 kicked in. When we put together our model plan in 2008, we needed concerns about the flat fee kind of contract situation. We had incentives to that monthly contract to allow for other, I'll call them hourly opportunities, so trial time, complexity of the case, and those kind of things. So the concern with Clark County is supportive of a change in the number, whether it should be legislatively mandated or allowing the counties to determine their own rate based on how economic supply and demand might get. So the rural counties supply concerns, but that the taking away that last sentence or last paragraph allows Clark and New Washoe to contract with attorneys on different than a completely hour rate. 67,000 hours that Jeff talked about is, and that was FY20 numbers, we tracked them for the last decade of those hours. We don't track as well the hours of our contract, we track case loads and workloads depending on where the status of the case is. And as Jeff said, the county is in the process of raising those rates for the contract. This amendment to 17.125 would suggest that every case from the start would be out for county that part with the volume, independent of $4 million through TPRs, guardianships, latency, and do away with our hybrid kind of flat fee hourly kind of incentive kind of model plan. The cost of the county would be astronomical.
And again, maybe this is a Marcy reference, that we have a July meeting. Between now and then, do we think it's possible? I'm sure it's possible, but I think it sounds like what we need to do is, can we add language that would allow for things like your attorney contracts, and also address the very real issue, which is Marcy and I have worked a lot in our relationship building, trust building with these counties, and they're sort of willing to do this in part because they're waiting on the reimbursements, but also because we've been able to assuage a lot of their fears that this isn't a state takeover, that we're not what to do. And my fear is that while, again, I love almost all of your idea, except that if they set a rate and we say, no, that's not good enough, you have to pay this, that's not going to sit well in a lot of places where they talk to.
so I think it's always possible to work on language and see what we can come up with. I joked with the committee that was prior to this committee was a Supreme Court committee on indigent defense. Several folks were on that for years. Franny, et cetera. When we came up with our model plan, I think that was like in 2008 or something, concerned even back then whether or not there was a disincentive to go to trial. The way we set up our tracks, because you automatically got the hourly rate for any of the track cases that you took to trial. I used to make the joke that they could get any amount of money they wanted. They just could take every case to trial and get tons of money. It solved that portion of the problem. My concern is still in part for Clark County, but it's also in part for the girls. The whole premise of this bill to work is that when we come back with a case load later and say they gotta add 6 more lawyers, and when we come back and put this dollar amount in here, is that all of these extra expenses are going to be picked up by the state. I'm going to use AB 424 as the example for this. One of my favorite assemblywomen worked on that. I tried to convince her that we should make that at 72 hours instead of 48 hours. The Ramos cases, you folks will recall, didn't put a 48-hour time period in it, said within a reasonable time. The expectation by the legislators was it wasn't going to cost the county anything. We've hired so far to date 30 additional people, including 14 additional attorneys, simply to shift to the 48 hours. And that's only because we had already hired enough for Las Vegas Justice Court, which is the main court, was already doing it in 24 hours. And so that's just to get our version of rural courts, our outlying courts, up to speed to be able to do the 48. The changes that are proposed here, particularly if it includes the tracks, is going to cost so much money. There is no way that I believe the legislature will fund it. And if they don't fund it, then they're not going to fund the additional attorneys that need to be put once you have the caseloads in the rural areas. We're going to defeat the whole thing. It is a good goal to raise the rates. I'm not opposing that. As I said, we're going to be opposing it ourselves in Clark County. But the way this is drafted at the moment and the impact it's going to have, I believe will wipe out the entire system of what we were trying to accomplish. And I know I'm being extra dramatic. I just think it's that much. I've been doing this for the last 15 years on one committee or another, trying to work on getting some of these things done. I think we're jumping too fast on this one because I don't think the money will be there to
I think the idea is that we need more time. It's obvious. So I think hopefully we can jump in and help. I'm wondering if we can, on the other side, we're asking the counties to pay more, can we incentivize and indicate that we're working harder for the training of our attorneys. You don't have to worry about a jury trial. You have lawyers who've never been to trial before. So I think if we indicate that our mission is training, so we're not going to have, okay, well, I'm taking everything to jury trial, or I'm never going to take anything to jury trial. We will have lawyers that can understand, yes, this needs to go, no, this doesn't need to go. And we will be facing DAs who know that they are, that they can do a jury trial or not. And they can have that, good information and experience. So I think, if we do it as a give and take too, which I think that's our goal is to have better lawyers, but paying $100, that's embarrassing. It's pro bono basically. And I don't think we can ask people to do pro bono. Unless do that as our job. But I think that if we, I think we can make it a meeting there. So I think we need more time.
Sorry. I apologize for monopolizing this. I'll try to shut up after this, but I recognize that statute says 100. Keep trying to emphasize that between our tracks, which I think run between 54 and 72,000 before you even add the we have a number of attorneys who earn 150, 200, I think the top was 200 and some thousand, 300 some thousand. Even with this language.
What if we bifurcated it to treat rural counties and urban counties different, so have the 100,000 population mark, and that protects Clark and Washoe's systems from, impacting the state, but also raises the rate for the other counties.
Well, it would get me to be more quiet, but my friends around here on the board probably wouldn't like it.
The only other option that we had thought about is to create an exception that says that this is the rate, the $100, $125, unless modified by the Board on Indigent Defense Services or Indigent Defense Service cases. So then that would be brought before the board, where we could modify based on need, what the hourly rate for certain counties might need to be to get individuals there. So that could be a proposal as well to bring it to the board, to give the board authority to set the hourly rate as an option.
And we have to be responsible for what we do, but the whole intent of reimbursements for the rurals, it's like, yes, this is gonna make your indigent defense systems more expensive, but you're capped. So the state is, arguably picking up the difference between 100 and 158.
Go ahead, Allison, you got something, and then I'll go to Commissioner.
So one of the things that we've done is we are reimbursing our experts. So how can we do that and say, no, you lawyers, I mean, even at this rate, it's a shockingly low rate. And when my experts are all making more than me, or twice, 3 times what I'm making, I mean, great for the experts, but what about the lawyer?
There we go, I think we figured it out. So, you're commenting my real job, I'm a farmer, so I do everything pro bono. So being the dumb farmer and a group of really smart people, I'm maybe have you go back a little bit and explain foundation here a little bit, because in Lincoln County, we have a contract public defender, and we have contract conflict counsel. And we send out requests for proposals, those proposals come in, we review those contracts and we make those contracts. The discussion, as I am understanding it, is that we are making an effort to adjust the rates for that conflict counsel to a set minimum. Am I understanding correctly?
It's for the appointed conflict counsels, and that it doesn't apply to anybody with contracts, like your contract conflict attorney won't apply to that. This is for the one-off appointed case.
Well, you say that, Tom, but the language would be hourly on every case. So if I'm a contracted public defender in X county, and I had 100 cases for that time period, I track my time, I submit a bill of 158 times that hours. Is that kind of what you're saying? Whether it's the public defender contractor.
The way this is literally written, a contract that has any flat fee in any county is drawn.
Right.
And they would start tracking their hours per case, and the hours would be at this rate. I haven't even got into all my complaints about how the CPI clauses are. Talk about that some other time. But in broad sense, you don't use CPI for the whole United States, you use the Western region minus California. There's just a zillion reasons not to do it that way, but it doesn't get to the base. The way this is written at the moment, I don't believe it's limited to contract counsel. I mean, just the one-off conflict counsel. I I believe this goes for the main public defender contract and the conflict contract and any other one. Every one of them would start tracking hourly, and all of those flat fee contracts would go away. Now, if that wasn't intended, that might be nice, and if I'm reading it completely wrong, you'll read it convinced, but I think at this juncture, and I'm not, and again, I'll stop, but I doubt we are going to resolve this topic today at this point in time. Throw out my next problem, I don't know, any one member of this committee needs to be here, but I won't be here on July 28th, and I won't be able to zoom in from the middle of the Atlantic Ocean. But so I'm hopeful at the end, we might actually talk about an August meeting instead of the July meeting. I know we have to have it in by September 1st, so that would still meet that goal.
I really appreciate that, because that helps me understand where maybe you might think it's not too far off, in that how this is applied could have significant impact in my county. And then just as a final piece, I personally stand completely opposed to using CPI adjustment on anything. I think that's a false narrative from the get-go. So I would be very opposed to using any kind of CPI for those wages. Thank you.
Drew, you have something else?
Yeah, just some thoughts, and I think we're all in agreement, and, I've been doing this for years. And we acknowledge that $100 of those 25, this is 2002. $100 in 2002, not a big thing. So that discussion about what the rate should be is an appropriate discussion. I think counselors to the point, many of our lawyers, my classes, and psychologists, and school market examiners, and DNA experts that we hire, our lawyers. But I do think it has to be acknowledged that each county is a little bit different with supply and demand, and the necessity on what it takes to get lawyers in that community. And I don't know if the right answer is to change the statute to make it a new number. To take the number out altogether, there was some concerns there. We took the number out last session of what the tax would be, right? So that was a step in the right direction. You want to have to use that as a burden to go uncomfortable going above. It's, that's something that's statutorily appropriate. But I do think we're limiting that last paragraph. I've always looked at this because I know many counties have contracts that not every case is captured hourly. I think that's where Commissioner Lister and Joni got the concern. So I think we're moving in the right direction. That the increases have to happen. We're in Clark County, allowed to put an agenda item out to discuss that. But it should be county by county analysis that could be difficult, right? If you put a floor, people tend to go to the floor, right? That's what the floor is. But it's just some food for thought with respect to what our discussions we can what's the best mechanism. I think your group always has the ability to go to a county and say the correct action and based on the mechanism. I hope this is a situation where we're so burdened by the costs that we lose the ability to we're here for is to improve the defense, not just in the rules, but statewide. And finances, unfortunately, require the also the state, the few purposes that we're here for sessions. And so let's be mindful that I think we need to encourage the opportunity for our lawyers to make more. Now, how we get there, I think is a more difficult discussion we're not going to solve today. Take into consideration. That is it legislative? Is it board? Is it county? Or a combination of three? How we get there is going to be somewhere.
Yeah, so I would just add to that. I'm like you, Commissioner. I've always hated CPI. Matter of fact, I kind of abolished it in our negotiations. It came back again this year because of the obvious. But that's hard to get away from when you're having those kind of negotiations. But what I think I heard you say, Drew, and I think I agree with it, is that every county is going to be different. And so we've got to leave flexibility. And in the end, the bottom line is for Lincoln County, for example, you know, if they can get by with $90 an hour, they can find somebody who's qualified, good for them. But the reality is in the marketplace and what it demands. And so when that happens, they're gonna pay whatever they have to pay to get people there to get the job done. And so that's where we need that flexibility.
And that's where all on. I too worked for $100 for, you know, nearly 2 decades, and it's, you gotta take other and work, because there's no way you can pay her on that, it's just not sustainable, just to rescue them, we were out talking to them the other day, so we have to use your words back, but this is where a lot of work. You know. So that's part of our sustainability thing, obviously, this is more complicated than we anticipated when we were drafting that, and all of that great ideas, and I just figure out some kind of solution that works everywhere so that we can build in the sustainability, because there are a number of counties who just can't attract attorneys right now to open contracts or to get, as we discussed, people to take cases. We have an idea down the road that we'll bring to you about modifying our regulations to possibly require at least a 2-tier system in every county. Second tier conflicts, like most of the counties do, but some of them don't. Obviously, we have 5 contracts that meets that requirement, but so it's all these different ways to find sustainability, but it's definitely a big piece of it, and it's really over time, something about it. We were trying to tie CPI, and obviously that's not the best idea. It's what the feds do, and it's so that we don't have to wait 20 years to marshal the political will to raise the rate again. You know, the last 2 increases were 1993 and 2003. You know, so it took 10 years to raise it $25 when it hasn't gotten since then. So we need to do something.
So I think we're sort of at a place here where we probably ought to just cut off the conversation. And I think somebody mentioned about a subcommittee possibly. That makes a lot of sense to me, so we can kind of hash it out. So I don't think we can make that kind of a motion today since it's not agendized as such, but unless I'm wrong about that, but if not, we probably should go about doing that somehow.
I'll chime in as the chair, you can create subcommittees on an ad hoc basis without needing to have a motion or pass a motion.
Perfect. Okay, that's good to know. So I mean, I'm happy to do that. But I have some volunteers who would like to sit on that subcommittee. So you know, Jeff and Drew would be good. Kate, please. Okay, there's 3.
Wait, you said you have volunteers who would like to. I will volunteer, I'm not sure I would like to.
I would like to.
And Allison
This
Johnson.
is Chris. I'm happy to volunteer.
And Chris is also volunteering. Is that enough? We got about 5 there, I think, right? That's probably big enough.
What's a quorum of the board?
For the record.
So we're more of that.
7 is a quorum of the board.
Okay. All right, so all of those, go ahead, Jeff. Sorry.
Take your vote first.
Okay, yeah, so all of those, we've got 5 individuals here. Do I need to rename them or Cynthia, you captured that? So we're good to go. So let's take a vote on that. All those in favor of these 5 individuals?
Vote on it, we can't vote on it. You
Well, I'm
make
just
it.
doing it.
You don't need a vote, yeah.
But when we.
Well, so be it.
Yes. We need to have a motion to table number 3. I'll make a motion. Mr. Chair, I'd like to make a motion to table item number 3. Request number 3 in favor of the subcommittee, which will bring a recommendation back to this board for its next meeting.
Okay, do I have a second? Do I have a second for Commissioner Lister? Everybody understand the motion? All those in favor?
Aye.
All All those opposed?
Aye.
Very good. I think she meant she was for it, so. All right, very good. So we've got a subcommittee established here. Go ahead, Jed.
This is just since Joni asked what the quorum was, as I remember this back when we passed our legislation in the first place. We have a quorum, which is 7, but action still takes a quorum of the board, not a majority of the quorum. So 4 people can't make, if only 7 show up, 4 people can't pass it. It still takes a vote of 7 to adopt any action.
And I believe didn't state law change at some time in the past where even the subcommittee has to publish its agendas and they have to be held as open public meetings?
I'll answer if can't be read. Yes, we need to publish notice and keep a record of the minutes of those meetings. Anytime there are 3 board members conversing on board business.
Okay, well, I don't want to argue. Is it 3 or is it anytime there's 2?
Committee or something.
It's.
Yeah, good for my information, so. All right, so Marcy and staff, will leave that up to you to get that kicked off. Okay,
We will do that.
so is there anything else on number 8?
No.
Let's move. Go ahead.
Peter, there's nothing that would bar any of us from monitoring meetings if we, once the agendas are published, if we wanted to just listen to the proceedings.
No, they're all open to the public.
Okay, great.
Very good. We're going to move on to number 9, budget. And I'll turn that over to you guys. Marcy?
Thank you. The first thing that I wanted to start with is where we are at for the maximum contribution formula reimbursements. As this board knows, we were able to make our first reimbursements to certain counties for case-related expenses. We've run into a little bit of a bumpy road with that, as Chairman Yola is aware, because he's helped us with this. And just for a quick recap, Assembly Bill 494, subsection 80, set aside funds in the interim finance committee contingency account to reimburse those Davis counties for expenses over and above the maximum contribution formula. As our board knows, we have more than a 1-part maximum contribution formula. The main part of it is that the maximum amount a county shall pay is average of fiscal year 18 and 19 plus inflation. We also created that subsection that said, if a rural county in their plan for the provision of indigent defense services allow for case-related expenses to be approved outside the judiciary, then those 2 also may be considered a state expense. So that initial request that we had put in to try and reimburse from those Assembly Bill 494, Section 80 funds, the funds that had been set aside. And since it has been determined that requests for those case-related expenses should not go through that process. When we request those reimbursements, we do not need to go to BOE. We simply go straight to the interim finance committee to request reimbursement, and it's up to the legislature. They had since changed the process. So last week or this week, we went in front of BOE, and this is subsection P on the memorandum I gave you, where we requested $136,268 from the interim finance committee contingency account to reimburse Douglas, Lincoln, Nye, Carson, Elko, Humboldt, and Pershing counties for costs associated with case-related expenses. So you see that in that request, there were Davis counties, there's non-Davis counties, but we are required to go after a different pot of funds to be able to reimburse those. When we did go to BOE, that was approved to move forward to the June 14th IFC meeting. So on that meeting, we're going to actually have 4 requests. One request will be to reimburse, we'll have 3 requests. One request is to reimburse from that Assembly Bill 494, Section 80, an allocation of $308,827 to reimburse Eureka, Lyon, Mineral, and White Pine. Those 4 counties have reached that maximum, of the fiscal year 18-19 average plus inflation in their third quarter reporting, and that's what we're requesting reimbursement for. Subsection O is an old request to reimburse case-related expenses for Carson and Humboldt in the amount of $8,960. And then we're adding to that $136,268 for the third quarter reimbursement for those counties. So all of these will be placed on the next IFC agenda next week. So that's where we're at. We do not know whether the case-related expenses will be approved, but we are asking for that to be approved.
So I just want to mention, so I got on the call expecting it was going to be a nice discussion. And day one, because I think we did it Tuesday, Wednesday, as I recall, day one was very adversarial. They did not want to pay these costs. And so there was a lot of questions around part two, especially, even though it was a much smaller amount. But in any case, I want to give Marcy and Thomas and Peter all the kudos in the world. They did a great job. Something happened behind the scenes because we got back together the next day and it was just, approve. It was done. And Marcy won't share with me why, but that's okay.
She's so intimidating.
That must be it.
Marcia, what counties do you approve the ancillary fees for?
We approve the majority of counties, so it might be easier to say the ones that we do not. We do not approve Douglas County. They've hired an appointed council administrator who's an attorney in town. In Carson City, the county manager approves those fees. In Lander County, they also have an individual that works for the county that approves those fees. And in Pershing County, they've hired a paralegal that approves those fees. Other than those counties, we approve all. Sue Savon is on the call today. She will be hired as the Churchill County appointed council administrator. We already talked to her. We started that process. So we'll be transitioning Churchill County back in her hands as well. But other than that, it is the department and it is that Nimra Perez, who is on this call, that's taken on all of these duties. And she's done a wonderful job. She's excellent at that position.
Okay, are there any other questions or concerns, comments on that area? Okay, if not, do we want to go, I thought we had talked about possibly bypassing the Churchill County discussion with Sue Savon's on this. Do we want to go to that item?
Yes, if we'd like to cover subsection 9B and 9C all kind of together in this next one. It won't take too much time. So although there's a lot of paperwork that we provided you, what we provided to you is the annual reports that we receive for every county, as well as any changes that they've made to their plans. We did try to do a quick summary for you so you would understand what modifications to the plans were, if there were any modifications. But overall, we have reviewed all of the plans as currently written. And we are asking that this board continue to approve all county plans as submitted. What Churchill County will be requesting is a modification or a correction for their fiscal year 18 and 19 reimbursement requests. When we talked to the county, there was kind of not a clear understanding of what was considered an indigent defense expense and what was not. And I appreciate Churchill County. They really certainly took this line of, you say we can't talk to the courts, we're not going to talk to the courts, and they just basically put down the number of what they felt that they had spent. When we're looking at what Churchill County has spent this year, it is nowhere near their maximum contribution minimum. So this is where we were concerned and actually reached out to the county manager, and they reached out to Sue, who's on the call. Sue took the opportunity to go through all of the spending for fiscal year 18-19, and it's in your packet as to what they actually spent on indigent defense and what they should not have reported. There were 432 expenses that were in there. There was expenses for a murder case that were included. So they are requesting that the board adopt their fiscal year 18 and 19 changed reporting forms And the department is supportive of doing this. We've talked that we believe it was submitted in error, and we believe that it should be changed moving forward. So our request today, when we asked to set those maximum contribution amounts for fiscal year 23, is to use those amended fiscal year 18 and 19 reporting as was submitted by Churchill County.
Thank you, Marcy. Sue, would you like to comment?
As the committee is well aware, transition is difficult, and Churchill County's understanding was they weren't supposed to talk to the court as we process through this. And I just retired as the court administrator from the 10th Judicial District Court on June 14th. And they have asked me to come in and kind of clarify what's going on. I had a better understanding of what we had been doing with the expenditures under indigent defense. We had formed a budget department within Churchill County that dealt with all of our indigent defense, including court-appointed attorneys, our interpreters, and of course that involves 432B cases, guardianship cases where the court's appointed, and also now we're appointing counsel to adverse parties in juvenile protection orders where the juvenile is the adverse party. Our county manager and our comptroller who were doing the reports to indigent defense were unaware of that fine tuning. And so approximately 30 days ago, they asked me if I would review and come up with numbers, because I realized the numbers were way out of whack. They were giving you the entire amount of what we were spending out of that budget, not just what related to criminal defendants and delinquent juveniles. And so I believe we've given you far more accurate numbers than you've ever had out of us. And I think moving forward, Churchill County will be a better reporter of data and statistics to help you achieve the mission that you guys are after.
Yeah, I'm ready for a motion.
Mr. Chair, then following the recommendation of staff and after hearing the explanation from Churchill County, the Churchill County representative, I move to allow for the, what am I doing, Marcy? The amended, yeah, to approve the amended Churchill plan.
I have a motion. Do we have a second?
Well, it's not really their plan, it's their maximum contribution formula, right?
It's there to allow them to amend their fiscal year 18 and 19 reporting.
My motion is amended to allow for that language.
Have a second from Kate. Are there any?
Marcel,
Motion? Yeah, I have one here. Go ahead, Commissioner.
I have one question.
While we're waiting for you to figure that out.
It's about the way the agenda item is worded. It says to discuss Churchill County requests. So we can take action on that.
I believe so, because in subsection 9, it says for discussion and possible action.
Okay, just want to get that on the record. Thank you.
Go ahead.
Thank you, Mr. Chairman, Bevan Lister for the record. So on the attachment, it is showing the costs that is 483 plus thousand. And then on the chart where it's showing maximum contribution for 23, we only have them listed at I just focus 375 plus. I'm just curious.
Thank you. Their 2-year average is actually, if you look at the blue table that you're looking at right now, their 2-year average when we take their modified reporting is $359,458.23. So they amended both their fiscal year 18 and 19 reports, which we provided in the packet, and that's what the average amounts.
So that attachment is just their budget for next year.
The attachment has their annual report, their plan as modified, as well as that prior fiscal year 18 and 19 amendment should be within.
Was there somebody online that had a question? Maybe it was Chris. Maybe I was hearing something. Okay, so if there's not any other questions, we have a motion on the floor and a second. Everybody understands it? All those in favor say aye.
Aye.
All those opposed? Okay, motion passes. Back to you, Marcy.
Thank you. So going to our news request, which is in that summary, again, we are requesting that the board, they feel it appropriate, approve all of the plans and budgets as were submitted to the department. The budgets were submitted in the annual report, which are attached, and we actually use these annual reports to determine the maximum contribution formula, or what we believe and recommend that maximum contribution should be for fiscal year 23. If you look at the table that we provided, we have provided their 2-year average. We've shown here their maximum contribution for fiscal year 20. And then the third line is the proposed maximum contribution with inflation. The inflation that we've determined was 4.52%. This inflation rate was found using a website which is listed on the table. So we provided that inflation rate for all of the counties. We've also asked in the annual reporting what the lowest rate of union negotiated COLA was, and where it says NA, that's not applicable, that the counties don't have any sort of union negotiated COLA, or they do not provide us with any sort of number. So the highlighted number in yellow actually turns out to be the lower of the two for the maximum contribution, and that's what we moved over to that general recommendation as to what the maximum contribution should be for each.
Any questions? Seeing none. Okay, if there's no questions.
One item I would like to clarify is this inflation was not compounded. So we went back to their average of fiscal year 18 and 19 and added inflation. It was made very clear by the finance office that there is no language to compound the inflation each year. So I don't know if that's the intent of the board in the maximum contribution formula, but in reading the regulation is currently written, there is no language about compounding interest rates. So we did not do that in this recommendation.
I think that makes sense. So do I need a motion for that? Please, anybody got a motion on this side?
Sure.
I move approval. Chris?
I'll second Chris.
You've been quiet. So I do have a motion for adoption and a second. Any questions on that motion? We do.
It's not really a question, it's just a snide comment to Marcy. Does this mean I should put a request in right now for 7 million?
Unfortunately, you've already submitted your annual.
Oh.
So it's okay.
Good try, Jeff.
I do have a comment about Sue. She just retired 2 days ago and she's appearing before us in this meeting. I hope you have a $500 an hour consulting fee for Churchill County.
At least more than 100.
More than 100.
Right.
There you go.
She's smart, no comment. So we have a motion on the floor. All those in favor signify by aye.
Aye.
All those opposed? Hearing none, unanimous. Marcy, back to you.
Finally, we are requesting permission, like we said, there are those 2 pots of money where we are requesting funding. One is the interim finance committee earmark funds that are set aside by NRS or Assembly So we are asking for permission to request reimbursement from those earmarked contingency funds. The approximately $1.2 million that's needed for the maximum formula for the Davis counties pursuant to our administrative code, section 16.1. And we are also asking permission to seek reimbursement for the inter finance contingency account as needed for the maximum contribution formula for those Davis counties when those earmarked funds are exhausted. Looking at the budget for these Davis counties, we believe that they will exhaust those funds, plus an additional approximately $1.4 million will be needed. For those non-Davis counties, we are estimating the need of approximately $938,000. So we are requesting permission as those reports come in to be able to request reimbursement.
Any questions on that request? Go ahead, Commissioner Lister.
Sorry, Mr. Chair, Bevan Lister for the records. I guess I'm a little bit lost on the agenda. Are we on 9D?
At this point in time, we are at 9B and C.
So still on 9B and C, okay. So unless I'm misunderstanding, you're asking us to approve your request.
I'm asking for authority when counties submit their quarterly fiscal report showing that they have expended more than their maximum contribution formula to submit a request to their finance committee for reimbursement on behalf of the counties.
It's good for the counties.
No, understood. At this point, I'm a little more, my government mind is working here and looking at the agenda and what we can take action on and what we can't. So I guess my understanding was that was already written in the regulations that we as a board didn't need to approve that on a regular basis.
I see what you're saying.
Because we're not agendized for.
You're saying she already has authority through the regulations, so why come to us to ask for the authority or the permission to go to IFC and request that funding?
Exactly, because we're not, we're not agendized for us to take that kind of action right now as a specific item, so, but I would assume the authority's already there. Just process question.
No, that's a great question.
So I would think it still would be appropriate for them to ask, because each year the dollar amount changes, and we're approving the dollar amount that she put in here as the base for them based on the inflation.
And that is correct. If I could add one more item. One question that we received when we submitted these requests is, do I have board approval to submit this request? And that's why I'm submitting this to the board, so I can have your approval to stand behind. Because that pot of funds set aside in Assembly Bill 494, Section 80, does have a requirement that it has to be approved by the board for that reimbursement. So that's why we're requesting that now when we're setting maximum contribution.
And I get that, I appreciate that, Marcy. I guess, like I say, the government training side of the mind is looking at this and saying, we don't have that listed as a specific action item on the agenda. And I'm good going forward with it, but in the future, it probably should be agendized separately as an approval item, because in this in item 9, it specifically says for discussion only, and then possible action. And this is something that we definitely wanted action on, so it should have been agendized as an action item specifically. I'll just, thank you, sorry.
That's a good point. Maybe even put the dollar amount on the agenda so that anybody who looks at it would have a comfort level that that's the number that they think they're entitled to.
And I have to be honest, as a 3-term Nye County commissioner, I wondered sometimes if the way our agenda is constructed, if it would meet the minimum requirements of the open meeting law?
I'll just note, I formerly used to work for the Attorney General's office and frequently helped assist boards in making these kind of determinations. I'm no longer acting in that capacity, obviously, with the now, so this isn't legal advice you're getting from me. So when we include language like
Proper disclaimer.
for possible actions, actually statutory authorized language, when you're gonna have an action item on the agenda. Possible action means that the board could take action or could not take action on anything within the purview of that item including the agenda. So if you're making a determination as to the contributions under subsection C, calculated maximum contributions for each county, that's something the board may take action on by labeling what it says for discussion and possible action. It could say for discussion and not have only in a possible action. I understand there is some confusion that can occur there, but the notation that there is possible action the board could take gives the board the authority to either take action or not take action as it sees fit. Generally speaking, without any legal.
I understand that, Peter. I agree with everything you just said. I'm only talking about the clarity in the individual agenda items themselves and whether they clearly define for the public what action we are taking.
And I think that it is up to this board to review the budgets of the county plans, which we have clearly said in there. We have to realize that a lot of these counties struggle with getting the annual reports to us in a timely fashion. So in the future, we do strive to put these amounts in there, but some of this information was received last minute. And I think that's another struggle that we had as well. However, the board does need to approve the budgets and the amounts that we are allowed to request over and above the maximum contribution formula. So that's what we're asking for here today is this board able to set the maximum contribution, which they have already done, and looking at the budgeted amount as the counties have budgeted, does this board approve those budgets and allow us to ask for reimbursement pursuant to the maximum contribution formula?
And I think it's fair to note that it will certainly moving forward attempt to have more detailed items in the agenda for the board's consideration of the funds.
Yes, that would be my request too. I'd like to hire you for Humboldt County's council.
I charge more than $100 an hour.
I wouldn't care if it would make it that much easier.
Can we negotiate with you for 90?
All right, so I think we got clarity on that, so we can move forward. If we're good then, we've got a motion on the floor. Oh, do we not? No, we don't, okay. That tells you about my memory. So, I am open to a motion on this side.
C and B, D and C.
B and C.
Allow them to go forward.
Yes.
So allow them to go forward, which allows Marcy to go forward based on the maximum contributions and the money allowed to the IFC to make those requests.
Can I ask to add something to the counties, we're looking at the counties numbers they have provided.
Maximum contribution budget.
I said,
So now we have a first and a second. Any questions? All those in favor say aye.
Aye.
All those opposed? Okay, we have a unanimous on that. So Marcy, I'm back to you.
And the final request that we have regarding budgets is, I'm going to request to be tabled. I'd like to let the board know how Interim Finance Committee feels about our case-related expenses, and whether or not Interim Finance Committee feels that those are a state expense or not. As we know, our maximum contribution formula says may. So at this point, I'm not asking for any authority to reimburse those case-related expenses until I'm able to update the board on what the Interim Finance Committee does next week, and whether or not they approve those requests.
Are you on 90?
Well, it's still on 9C because these have to do with the maximum contribution. The maximum contribution, as we know, has those two separate subparts. There's the fiscal year 18-19 average plus inflation, and then there's also the possibility where case-related expenses may be a state expense. So under that maximum contribution discussion, I was just going to bring up the case related expenses portion of the formula. And whether or not the board would like me to continue to request reimbursement, or if the board would like to see what interim finance does next year.
What is the argument that they are not case related, they are not, shouldn't be funded by the state, those case related expenses?
So if I have in the items, I have the section 80 of Assembly Bill 494. And this is what they're relying upon to say that these funds that were set aside, that approximately $1.2 million, are for allocations to the Department of Indigent Defense Services to fund costs in excess of the estimated county maximum contribution amounts for the provision of indigent defense services for the 10 rural counties. So feedback that we've received is that case-related expenses, when they haven't met their maximum contribution, are not considered costs in excess of their maximum county contribution amount, and that we're not allowed to request reimbursement from these funds. It says that money appropriated by the section may only be allocated by the ISC upon recommendation of the governor, submitted by the Department of Financial Reports demonstrating costs in excess and up to the amount approved by the board. So that's why we're requesting the board's approval to go get those funds. Another concern we have is that these funds are in there for a limited amount of time. They cannot be committed for expenditure after June 30th, and they have to be distributed to the counties before September 16th. So that's why we're asking authorities to move very quickly. And we're actually going to be reaching out to all of the rural counties to try to get them to submit their final fiscal quarterly report prior to the 15-day deadline, so that we can make sure our interim finance committee request is done on a timely basis.
Was that language written by LCB?
Yes.
So if I was a cynic, I could say that because LCB left out part of the statute, how they wrote it, they're not using that as an excuse not to pay it.
And we do have our request on the agenda for next week, so we'll be able to update you.
Okay, is there anything else on that? Marcy, you got anything else, sir?
No. We just asked to be able to move on to the discussion of the department budget bills, and to give this board some idea of where we're going with our budget bill at this point in time. We have discussed a little bit about what Dr. Mitch Sobel was hired to do, and that was to review the public defender salaries as compared to the Attorney General's office. And based upon his report, we did submit a class series compensation plan request. And our request, we realize is just a start, but what we'd like to do is bring our state public defenders up to the same pay rate as the Attorney General's positions. So if you review his report, you can see the shocking pay disparity between state public defenders and county employees, as well as state public defenders with the Attorney General's office. One highlights the fact that in the state public defender's office, they have a deputy public defender, but they don't have any ability to move in within the public defender's office. There is no senior public defender position, like there's the equivalent senior deputy attorney general position. But in reality, what the public defender has is a chief that's paid at the same rate as a senior deputy is, although they have increased duties that they have to comply with. So we did submit a request to increase the salaries of the public defender's office to make them consistent with the Attorney General's office already has, and that's what it's submitted to. Another request that we wanted to touch upon is.
Marcy,
hang on.
go ahead. So I have a copy, or we all have a copy of your May 31st letter to the governor's budget office. And I understood the explanation for the state public defender's office and all those requests. It also includes for yourself, and looks like Tom and Peter in there as well. I'm wondering why we chose to compare those salaries to the Attorney General's office. Since you're doing it statewide, part of the statewide includes Washoe Clark, I would make the argument that both yours and Peters and Thompson should be a higher request than this, because at the moment it's even less than just one of our chief public defenders, just one of the track guys, not even somebody who's in leadership like you are in a statewide role. So I get the state public defender, because on parity they're having trials against the Attorney General's office. It makes logical sense to make parity there. Your parity shouldn't be limited to that.
And I think answering for Dr. Sobel, he does point out on page 3 of his report that the Clark County public defender salary ranges are about 52% higher than our salaries here. But we did just choose the Attorney General's chief of staff for comparison, unless the board would like to direct us to a different route. This is been submitted, but we are in the process of our budget bill, and this request was due on June 1st.
Well, I'm gonna throw out something then, just for the top 2 columns there, instead of the requested 150, instead of 158, let's make it 168. Instead of 149, let's make it 159. Let's set 10,000 each to those 2 categories. Interesting enough, that's still below the Clark County Chief Public Defender, but it's not trying to compare it with the AG's office. It's trying to do a balance within the state.
Yes. So we have a motion and a second to increase that $10,000 range on both the bottom and top end. On both positions.
Now, the letter's already submitted.
They can tell them what board actions are.
Board action, or I can submit an amended and say that there was board action. If you would like.
So we have a motion on the floor. Are there any questions about that? If not, all those in favor say aye.
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 All those opposed? Unanimous.
The next thing that we want to touch on is the organizational charts within the departments. And we provided you with org charts so that you can view what we would like to add. And the orange positions are what we would like to add. So it's pretty significant what we're trying to do in the overall change. Starting with the departments. Right now, we have 2 deputy directors. We have Tom, who's in charge of oversight, and we have Peter, that's in charge of resources and improvement. But we don't have anyone that's in charge of finance or funding, reviewing the annual reports, applying for grants, and just trying to go out there and finally get federal funds for public defenders, which there's a lot of federal money out there, and no one's asking for it on behalf of the public defenders, especially in the state. So what we are proposing to do is to add a 3rd deputy director position to be in charge of funding. Under that, we would like to have an ASO, which is a budget and accounting analyst. I don't know if the board is aware, but the department, the highest fiscal person we have in our department is a management analyst. And we are required to build our budget, which means that Peter and I are taking lessons on how to build a budget so that we can submit this with the appropriate time range with Jamie Hamtack, who was recently put into the position of our management analyst. So we would like to have fiscal oversight of an ASO because this is the level where the ASO generally is responsible, not the director, deputy director, for building these budgets. So we're hoping to alleviate some of that burden by having fiscal person within our department. That first fiscal person would be able to also assist with oversight. We have these reports coming into us. We're not able necessarily with the limitation that we have to audit these in any way. It's based on each county certifying that these are valid expenses. And we do believe that we are certifying those appropriately. But it may make the state more comfortable if we are able to audit those as necessary. Underneath that, we'd also like to add a grant specialist. This is someone that can be in charge of applying for these grants and applying, submitting all of the paperwork. Peter has discussed the grant that we received to be able to pay for our rural public defenders to go to that training, and that was basically on Peter's shoulders. Peter's been submitting those quarterly reports. Peter's been in compliance with the grant reporting that's necessary. And I think that's pretty much your first grant that you've ever done this for, right? So we're kind of learning very quickly how to do grants, but I think we could do a lot better if we had specialists to cover this. We also have another grant, and it's for student loan forgiveness. We recently submitted that request with the assistance of another department in the state. They helped us fill out forms. So it'd be a lot easier for our department if we created this fiscal side for indigent defense services. Under that funding director, we are hoping to move that from the position of an administrative assistant to a project officer. So that is hired as an administrative assistant, yet she's taken on this assignment and selection of counsel, meaning that she is preparing pleadings to be submitted to the court so that they can sign off for the appropriate for the selection of counsel. She's in charge of entering cases into the legal server and transferring them to the appropriate attorney. And she's in charge also of, when we receive a case, making sure that we find appropriate counsel and notifying Peter and I if we're unable to find anyone to cover it. So we are asking to be able to move her up to a higher position of project officer because she is far exceeding those duties for an administrative assistant too. We have a request in to do a reclassification for her. So if that reclassification is allowed, we would not need to make that a new position. It would just be created there. It would create a new AA2 position. If that reclassification position is not allowed, we are going to be asking to create a project officer because they need to be in charge of the assignment and selection of counsel. It is quite a bit of work for people to do. The next area that we'd like to improve is under the oversight. Right now, Tom has said that our main concern is going out in relationship building, talking to individuals that are in each of the counties and just building relationships. So we don't have a lot of time to sit in court and watch what's going on. We are hoping to create policy advisors, 2 positions for policy advisors that could either work together, or one could be on the east side of the state, the other could be on the west side of the state, so that they can go to court and be available to do oversight as necessary. We believe that these would be attorney positions and would be similar to a deputy public defender in the pay scale. So we're hoping to add that in. And then finally, what we are hoping to add within our department is a holistic resource center. We want to be able to provide those rural public defenders with the same resources as attorneys have in those urban counties. So that means that we're hoping to have a social services manager that can create relationships across the state for mental health care providers, substance use providers, so that when public defenders from the rural counties call up and say, you know, I have this issue, that social services manager could direct them in an appropriate way to be able to get help with that. We also wanted to have 2 staff social workers that could help those rural attorneys with case management, because these rural attorneys are basically doing it all. They have to deal with the criminal case. They also have to deal with getting their clients into an inpatient, which means they have to print out a form, fill out the form, have their clients sign off on it, submit it to each of those inpatients. And we believe that their workload could be alleviated if we can provide them with a social worker to help with that case management. We also hope to have an on-staff investigator that would lend out to those rural counties. Some of the rural counties have expressed frustration that because they don't have staff investigators, sometimes they have a hard time finding someone willing to take the case because it just isn't that interesting, or they have a hard time controlling what those investigators are doing. So we're hoping to have that.
Is one going to be enough? Yeah.
And it's a start.
We have to start somewhere.
And we do appreciate input on this. If we would like to have more than one investigator, we can have one on the east, one on the west. And we'll build this as the board feels appropriate.
me, the whole issue is what's the legislation going to fund realistically?
We're
Maybe
also,
not even one position.
we're also anticipating that if, the reimbursements come in, that, there will be counties that add investigators, into the organized office or somehow. So, the only one.
And, so if the board would like, we could add additional investigators in our budget bill. And finally, what we hope to provide is mitigation specialists. At the training that we put on, we talked about the importance of a mitigation specialist, not only for death penalty cases, but for all cases. Just a murder case where there may not be death penalty, that mitigation specialist could make a difference between a life sentence or a determined amount of time. So we're hoping to provide those rural public defenders access to mitigation specialists that can help them really present their client to the juror or the individual at hand that's determining the sentence. So those are our changes that we'd like to see in the Department of Indigent Defense Services.
Marcy, this is 12 positions you want to add. What's the value, the dollar value of these positions?
Well, we haven't quite started working on that yet. We have determined what we'd like to pay for each position, but we haven't put the budget together. We're in the process of learning how to do the budget and then setting the money up to be able to do that. But I think at the next meeting, we can have a better number for you as we talk a little bit more about this.
So in Clark, we require our departments when they put in requests for additional positions to rank them and to budget them at midpoint of the salary range that predetermined, plus add capital costs that might go with risks, et cetera. Does the state require you to put all of that information in as well? So was your order that you just explain those the order of your priority, or what was your order of priority?
We haven't necessarily discussed the order of priority. All of these are extremely important. Would refer to the board on guidance so that obviously one person performing oversight is not enough. This state is so big, it takes so long to get here. It takes a long time just to get to Pioche, to Caliente, to Alamo, all of these places just in Lincoln County are quite a drive for us to be able to go meet with individuals and talk to them. The funding, I feel like we're leaving money on the table that we can have. We've been successful in a lot of our grant requests, but that's just the three of us kind of putting together a grant request. But maybe we have an individual that knew a little more of what they were doing, we could bring home a little additional funds.
Just for me, I'm happy for you to put it forward. I just, joining with Joni, I'm kind of concerned whether the state actually would go forward with these. That's why the priority question. I wouldn't mind, even though there's 12 positions here. I think if you're going to do it, you need, just like you had 2 social workers, I think you need 2 investigators and 2 mitigation.
Tracy.
What was that, Chris?
That's water.
Chris.
Nothing, I'm sorry. My dog was getting into trouble. Sorry.
Yeah, so I would say, yeah, go big or go home. You gotta give them the big picture, I think, of what we'd like it to look like and, what we think we can do to, again, continue to have improvement and excellence. So I think that's a good idea. Just look at the numbers. I would suggest you're gonna triple the budget at least. But at the same time, if we're really gonna do the whole job, the only concern I have is just like the oversight, things I just wonder, we have to approach it properly, especially with the rurals, having people looking over their shoulders and things like that. I mean, I think it's probably valuable.
Some of those shoulders.
I'd be concerned.
Speaking as a frontier person.
I'll defer to maybe you, but the budget process is better than where everything that you just think of what your long-term goals are, or should we limit our requests for 1 or 2 this year, 1 or 2 next year? More realistic shot at getting what we want. So that, but
I'd like to defer to the commissioners, since they've sat in front of those presentations with guys like me. I like to show the big picture, where we're trying to go, and then we never get it, so you get what you can, I guess. So the commissioners, I'd love to hear.
And Marcy, is your office space wouldn't be big enough, obviously. So that adds a whole other escalator.
And that's the interesting thing, talking about the fiscal oversight. I don't think we've ever wanted to be someone looking over shoulders all the time, but we want to be a resource. We had the opportunity to go in and watch court, and we've seen certain arguments, and it kind of developed a discussion of, have you thought about possibly this or this? And, it's not necessarily us saying you're doing anything wrong, it's just, sometimes when you are doing the same thing in the county and you don't see different people coming in, you're just kind of used to things going a certain way. So it's nice to bring in the perspective, it's nice to build these relationships. But that's kind of what we've seen so far. And the question as for oversight is, would these people be in Carson City, or would they be maybe on the other side of the state? These could be individuals that are in different rural counties, they have easier access, and it could just work remotely.
Austin's the geographic center of the state. So.
Yes. Not the population. So.
Marcy, what's the second page? I noticed it's, the state public defender's office. That's certainly, but are they asking for new positions too?
What we've requested in the annual report is, are any counties going to be opting in to the state public defender? And as you can see in the annual report, there has been some interest in some counties opting in fully. There's been some interest in counties opting in for the appellate, and there's been some interest in counties opting in for our complex litigation unit. So what we have presented on the next page is kind of what we think our vision is for the state public defender's office. Right now, as we're aware, because we have the salary survey, it is the state public defender, and then there's 3 chiefs that make the same pay scale, although they have different duties. There's the office chief, and then there is the chief appellate attorney and the chief trial attorney. So what we're proposing is to reclassify the chief office attorney and make them an assistant public defender. And that is more in line with their duties and what they'll be required to do in those positions. And we're actually kicking around the idea, I don't know if it's appropriate, but of having 2 assistant public defenders, one for the eastern side of the state that is also over the complex litigation unit and the appellate unit, and any counties on the eastern side of the counties that would like to opt in, and one for the western side of the states that also has the state public defender in Carson City. One of the biggest things that we're proposing, or would like to propose in our budget bill, is to have an office for the public defender in every county where they have a contract. So at this point in time, Carson City, the state public defender represents individuals in Carson City as well as Story County. There is no office in Story County. They have to drive up to court, which is about a 30-minute drive, to be able to represent their individuals. And our main concern is there is no public transportation between Carson City and Story County. So if you want to meet with your attorney, there's not really any location other than in the courthouse to be able to meet with them. So we're hoping to create offices in each county so that we can build those relationships further locally, as well as have a place where individuals can actually meet with their attorneys in their office space. I think it also makes the trial a little bit easier when you have a printer and your computer in the same county where you're doing the return. So those are some goals of creating those offices. Little details. So the biggest thing that we're proposing is to separate the appellate section from the Carson City Public Defender's Office. Because that appellate section would be serving the entire rural states and those counties that are opting in. It wouldn't just be Carson City. So we'd like to take that supervising chief public defender and make them in charge of the appellate unit with 1 to 2 deputies under the unit. It depends again on how many counties are actually going to opt in for that appellate representation. For the complex litigation unit, we would like to have a supervising public defender, and likely this would need to be a contract position because of the state salary. I don't know if we'll be able to hire an individual that's too good to be qualified for the rate that we're allowed to make in the state public defender's office. And underneath that complex litigation unit, we'd like to have the supervising secretary, an investigator, and litigation. The other side that's been a little bit cut off is we'd like to create more resources in state public defender. Right now they have 2 investigators. We'd like to create a chief investigator position, so it's not leadership, that's something similar, that's in the Attorney General's office. And we'd also like to create social worker positions and a supervising social worker. So if counties are operating in the whole defender's office, they would have access to those resources.
Thank you, Marcy. All I know is that my commissioners are listening to this, they all have heart attacks. I love the vision personally, and where you're trying to go with this. It will be great to see what kind of traction you get on this. So, any other comments, questions?
The challenge will be to sell that vision.
Exactly. Yeah, I agree with that wholeheartedly. How do you do that? And I think that will be your big challenge.
Everybody wants quality indigent defense until they find out it's gonna cost money.
Unless they're charged.
Oh, if he ended the death penalty, we could save some money.
Chris, as you probably know, that bill has passed the assembly twice, and magically was not heard in the Senate twice because of the Senate committee floor leadership.
Yep. But that aside, I think Marcy's laid out a good plan. If you want a department to work, you have to have the right leadership in the right places. And unfortunately, I could say in my 16 years in the legislature, we never paid state staff as well comparably. And so we constantly train them and lose them to other organizations. And so I think, we'll see what happens, but I think it's the right thing to do is to ask and at least lay out the vision.
Do you need a motion, Marcy?
No, I just wanted to keep the department or the board updated on what we have our vision to be. And as we schedule the next meeting, we should have more information for you as to the cost, the priorities, and if we can get all this done before September 1st, that is our best plan for that.
Is your plan, you may have mentioned this earlier, but like we're talking about, you can go for just a few pieces of the big picture. Is your plan long-term to go to the legislature, show them what the big plan is, with the idea of knowing you're not gonna get it all, but I think it goes back to Jeff's comment about priorities. Once you do that, if you have priorities, then I think you're gonna have success in picking things off one at a time.
Thank you for that. And I think one difference that we have are things that are mandated, I think, have a higher priority level. So if counties can opt into the state public defender, that will be submitted as our budget as an M item, which is a mandate pursuant to the statute. So we have counties that are interested in the complex litigation unit, which would be required. And we also have counties that are interested in the appellate unit that needs to. So we will be submitting those appropriately, but any other advice you have on budget, we are all ears.
We also did present to the judiciary. So
and we're hoping that we can get some support from the sentencing commission. Apparently in their assembly bill, if they can find, they believe that by changing criminal justice, the system how it's currently set up, that we are saving funds for people that are incarcerated. The holistic resource center that we are proposing to build, there's been a RAND study behind it that says that in the Bronx, it saved $161 million. It reduced the rate of incarceration for individuals, and if they were incarcerated, it reduced the length of time. So we do have evidence-based material showing that if we build this holistic resource center, that it would actually save money in the correctional side of things by treating the individual as a whole rather than just dealing with that criminal piece in front.
Marcy and Dave, I seem to recall looking in past years at the opportunities to opt into the state public defender's structure. And it actually costs more money out of pocket for counties to do that than to maintain their current modified flat fee contracts. Is that still true?
I don't think that's true anymore because we set the maximum contribution formula. So if you look at the maximum contribution that you set for certain counties, that's the maximum that they can pay. The rest we have to request from the general fund to be able to fund those offices.
So we got away in our county, we went away from the state public defender because our indigent clients were not getting any kind of service, much less good service.
And I don't disagree. I think part of the problem was state public defender's office seemed like it was set up to fail.
Yeah.
When you don't have an office in the county that you're supposed to represent individuals, how do you connect to that community? And that's one of our main priorities is we don't want to make a public defender come to work in Carson City and then drive an hour and a half to Yerington and be expected to stay until 8 o'clock at night. We want to have an office in that county where they can be centralized to be available to that community. And that would be our proposal.
So right now, there's no real financial incentive for counties to go away from their modified flat fee contracts and join the public defender's office, correct?
The financial incentive. Essentially, the cap, the maximum that the county has to pay is the same regardless of the organizational structure of the county.
Yeah, that's true.
And so that's, you're right. That's one of the things we're trying to educate county management on as we travel around and just let them know the other options. Sticking with the flat fee contracts, which will perhaps need to be modified in some way once we come up with the caseload study. I do think it'll be tied to an hourly rate. But you know, whether it's a county organized office, the contracts, or the state public defender, the cap is the cap. And so, you know, I think it's important for counties to look at all of the different options. And we're just encouraging sustainability. And what system can you set up that allows you to bring in, you know, say younger, inexperienced attorneys to create a pipeline so that when they come, they get those skills, they become someone who can bring other people and those kinds of things. So we don't have the situation that we have in a lot of places in the state where you've got one person that's held that contract for a decade or more, and then they go away, and then they back. Somebody else covered that.
And the only other thing I wanted to add is when we're going out and we're talking to the attorneys, what we're learning is a lot of them are very interested in getting into a retirement system. A lot of them are very interested in getting some sort of health care. And a lot of them are very interested in student loan forgiveness. These contract attorneys don't qualify for public service student loan forgiveness. They also don't qualify for the grant that we have to assist with forgiveness of student loans because they're contract attorneys. They're not part of an organized office, not set by federal law. So in order to provide that incentive, which could be another pipeline, would be to encourage counties to create a county office or go to the state office, whatever works better for that county, so they can have those incentives.
Tom, if I understood you correctly, that's, I think, how I understood it. If we took County X and their budget at the moment is 500,000, that's their cap. And under that 500,000, they spent 50,000 for a pellet and 450 other ones. If they chose to have you folks take over the appellate unit, they might still have to spend up to the 500,000, but now they would be able to have either an additional attorney or a higher rate of pay for attorneys to get to that 500,000.
That seems to me, Churchill County, example where they run contract attorneys and have now gone to, an institutional, however, it looks like they still have a contract for conflict. So I think that's a good thing, because it's gonna be different. We found it to be good to go long before I was there. And it's worked out very well. But it's gonna be different for everyone. So do you have anything else on that, Marcy?
No, I'm done with number 9.
Okay. We're done with number 9. We don't need anything on that, right? That was just informational.
That was just informational.
Okay. All right, so let's move to number 10, future meetings. I know, Jeff, you made a comment about you being gone for the July meeting, so do you want to comment? I don't even want to know where you're going, just
So
say what you gotta say. would you?
the comment would be, and I think there might be somebody else who can't make it on that July 28th date. I'm just wondering if we could push it to August 4th. It's only 1 week later, and but if other people that interferes with their calendar, then obviously mine doesn't take precedent. I just making a question.
And I don't know if this is a possibility, would we be able to go earlier in July? We will be doing our 4th quarterly fiscal request, and if the board would like to see what we're asking for from IFC. I don't know if they have. Because the 4th quarter fiscal reports are due July 15th, and we'll be prepared for that. So if the board would like to see our request and support it.
So
that's possible.
without going through all the boring details, I won't be available from July 13th through August 1st. No.
The department is available on August 4th if you'd like to move to that date.
I gotta miss that one too, but I'm unfortunately not on the 20th.
The 18th.
August 4th works for me still. Excuse me.
I have lots of meetings.
Yeah.
4th works for me, as does the 11th.
And Chair, our budget is due September 1st. If you'd like to go into that one of the last 2 weeks of August, if everyone can be there for that, we can finalize our budget with the board.
Chris, can you do the 18th?
Chris, did you-
Of July or August now?
August.
August 18th. I'm available.
Okay. Got a lot of hit sheet down here, so.
Move the 28th to the 18th.
Very good.
And Chair, would you like to set a meeting for the subcommittee at this time, or would you like me to email them?
Why don't you email them and work out proper dates, and you can tell me or us when you know that. Anything else? 11 is public comment, so is there any public comment?
Nothing written received.
Okay, very good. I'll move to number 12, adjourn. I adjourn this meeting. Thank you, everybody. Appreciate it.
Good job, Dave. Thank you. Take care.